Well, good morning, everyone. This is John Neerman, and it's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, January 27th, 2021. The time is 9:30 a.m., and I'll begin with the roll call. Commissioner Lindley, good morning.
Good morning.
Good morning, Commissioner Janeka.
Good morning.
Our commissioners are all present, and how about our general counsel? Ms. Smith, are you there?
I'm here. Good morning.
Good morning. And our public interest counsel?
Good morning. I'm here.
Good morning, Mr. McWhirter. I'd like to remind folks to keep their phones on mute when they're not speaking. I'd also like to remind anyone who's here only to listen that they can watch the meeting online, and that link is available on the agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits. Registration closed at 9:30, but if you'd like to address the commission on a particular item, please email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to comment on, and we will do our best to accommodate the request. For those making presentations, please wait to begin your presentation until I or our general counsel have asked you to begin speaking, and please check to make sure that your line is unmuted before you speak. And with that, I'd like to thank everyone for being present. And Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the application by Tycon Ready Mix, LLC for issuance of air quality standard permit for concrete batch plant, registration number 159582. The parties have been notified that the commission will not take oral argument but may ask questions. And those who have signed in on this item will be noted for the record.
Thank you, Ms. Smith. And for the benefit of those who are not familiar with our process, we have a two-part analysis for considering requests for contested cases. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. Then, assuming that at least one requester has met those requirements, we consider which issues are appropriate to refer for hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public, who have articulated personal concerns that are relevant and material to the permit, and have done so both in timely comments and a timely hearing request, are entitled to a hearing. In addition, for concrete batch plants, such as this item that's before us now, the Texas Health and Safety Code section 382.058C limits hearings to those persons actually residing in a permanent residence within 440 yards of the proposed plant. And colleagues, we have numerous requesters on this first item. 6 of them have shown that they reside within 440 yards and have met the other procedural and substantive requirements for a hearing. At least that's my view of it. And those 6 are Deborah Burkett, Robert Burkett, Frankie Burkett, Janet Johnson Burkett, Leah Michelle Carter, and Gina Davis. So I would grant their requests. There are 3 requesters who reside close to the 440-yard boundary, and it's not entirely clear whether they are within it or beyond it. At least it wasn't clear to me. One of these, Mr. Ashby, failed to file any comments, so we're going to have to deny his request. The other 2, Brian and Shelby Burkett, have met all the other requirements for a hearing. Just this open question about how far they are from the proposed facility. So what I'm going to suggest is that we refer their request to SOA to determine the precise distance and then whether or not they're entitled to a hearing. The remaining requesters either fail to provide a residential address or are shown not to reside within 440 yards. So I think we should deny those requests. And let me pause there. That works through all of the requesters. Let me pause there and gather your thoughts, Commissioner Lindley.
I'm in agreement with everything you've said so far.
Thank you. Commissioner Janeka?
Likewise, I reached the same conclusions on effectiveness for those requesters, and I'll only add that I believe one requester made a request on behalf of themselves and on the church that they are a pastor for, and I don't unfortunately find that the statutory requirement is for residency. So I think that it's worth pointing out that that church will be represented because I believe that that requester lives within the same distance. But thank you.
Yeah, I appreciate you pointing that out, Commissioner. All right, sounds like we're in agreement on what to do with the requesters, which to grant, which to deny, and which to refer over to SOA for a determination. Let me turn to the issues. And again, for the benefit of those folks who aren't familiar with our process, we refer issues of fact that have been timely raised by an affected person and that are relevant and material to the application. And to put that another way, the issues have to be within the agency's jurisdiction on this type of an application. So, for example, we can't consider economic impacts such as effects on property values. Also, because air permits authorize only the air emissions, we can't consider water quality concerns in connection with an air permit. We don't consider traffic, noise, and so forth. So looking at the issues and determining which ones are relevant material here, I would organize the issues into 4 separate issues. The first is whether the draft permit is protective of the health and safety of the requesters, along with their families. Number 2, whether it will adversely affect air quality. Number 3, whether it will be protective of general welfare, including plants, animals, and the environment. And 4, whether it will protect against nuisance, dust, and odor conditions. So that's where I land on the issues. Commissioner Lindley, how does that sound?
Sounds good to me.
Commissioner Ginecca?
I'm also in agreement.
Okay, I think it makes sense in this case to include an ADR referral and also to allow the full 180 days for the hearing. And if that is agreeable to y'all, I'll entertain any additional thoughts or a motion.
I'm good with that. I can try a motion. Make sure I include everything. I move that we grant the hearing requests of Deborah Burkett, Frankie Burkett, Janet Johnson Burkett, Robert Burkett, Leah Michelle Carter, and Gina Davis. Refer the hearing requests of Brian Burkett and Shelby Burkett for an effectiveness determination. Deny all the other hearing requests. That we refer the application to SOA for a contested case hearing on the following issues. Issue 1, whether the draft permit contains adequate conditions to protect the health and safety of the requesters and their families, including sensitive subgroups. Issue 2, whether the draft permit will adversely affect air quality. Issue 3, whether the draft permit will be protective of general welfare, including plants, animals, and the environment. Issue 4, whether the draft permit contains adequate conditions to protect against nuisance dust and other conditions affecting the requester's properties during operations. And hopefully I said this right. And refer the matter to ADR to run concurrent with the scheduling of the SOA hearing. And that we set the hearing duration of 180 days from the day of the preliminary hearing until the proposal for decision is issued. And I'd like to pause and run that by Mary and see if I need to correct anything.
There was one matter in issue 4. My phone went in and out, and I wasn't sure if you said odor or other conditions. I think you said odor.
That's correct. And I will clarify. So issue 4, I would refer would be to whether the draft permit contains adequate conditions to protect against nuisance, dust, and odor conditions affecting the requester's properties during operations.
Commissioner Lindley, and I'm going to butt in before I get a second or a further comment. I didn't hear an ADR referral in there, and wondered whether you thought that we should include an ADR referral
I believe I heard one, Chairman.
Yeah, I tried to say it, but I can,
Okay. Commissioner Janeka, you heard an ADR referral? Okay.
Mary, was that correct?
Ms. Smith, did you hear the ADR referral?
I did.
I'm sorry, I was probably looking ahead at the next item or something and momentarily tuned out. I apologize for that. I will trust you that there was an ADR referral in there.
I will say one more time for the record that after those 4 issues, I would like to include in my motion that we refer the matter to the committee, the Alternative Dispute Resolution Program, again, to run concurrently with the SOA hearing. And that concludes my motion.
That works for me.
Second the motion, as clarified and repeated.
Ms. Smith, does all that work for you?
It does. I understand from the ADR program that one of the necessary parties, just to throw a wrinkle into this motion again, for ADR has declined to participate, and so they are no longer recommending referral to ADR. So, if you, obviously you can keep it in there. It may be.
I propose we move forward with the motion as stated, and the ADR program may discover really quickly that there's no work for them because one of the necessary parties doesn't want to participate, which happens from time to time and is fine. Perhaps that party might change their mind looking at how things shape up, but I don't think there's any harm in moving forward with the motion as it's been proposed. Agreed, colleagues?
Agreed.
Ms. Smith, does that sound all right to you?
Yes.
So with that, go ahead, Ms. Smith.
I think we need a second still on this one then.
I will second that motion.
Okay. All right. With all that out of the way, let's take a vote. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
And I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 2 is the application by Crossroads 10445 LP for new Texas Pollutant Discharge Elimination System permit number WQ0015810001. The parties have been notified that the commission will not take oral argument but may ask questions. And I don't believe we have anyone signed in on this one.
Thank you, Ms. Smith. And colleagues, again, we first consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And again, requesters who are affected in a manner different from the general public, who have articulated personal concerns that are relevant and material to the permit, and have done so both in timely comments and a timely hearing request, are entitled to a hearing. We have 7 requesters in this case. The only issue that was raised during the comment period is flooding. But the commission, as you know, lacks jurisdiction to consider flooding issues as part of the wastewater permitting process. And we're unable to look at other issues that may have been raised in the hearing requests. So I'm afraid that we are compelled to deny these requests. I'm certainly sympathetic to the concerns that have been raised, but the commission is simply not in a position to address them, in my view. Colleagues, am I missing anything, or would you like to add anything, Commissioner Lindley?
No, I think you stated everything well, and I'm in agreement of denying the hearing request.
Thank you. Commissioner Janeka?
I am in agreement, a little disappointedly so. I think that there were some good concerns raised, or valid concerns rather, fair questions raised in that later hearing request letter in October 2020 as compared to the October 2019 letter, but the constraints of the law direct us to narrowly consider those factors at that time. So a little unfortunate, but I agree with you, Chairman.
Thank you. I'll entertain a motion.
I will move that we deny all hearing requests, deny all requests for reconsideration, grant the new Texas Pollution Texas Pollutant Discharge Elimination System Permit number WQ00158100001 to Crossroads 10445 LP and adopt the Executive Director's response to comments.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 3 is the application by Quadvest LP for new Texas Pollutant Discharge Elimination System permit number WQ00158250001. The parties have been notified that the Commission will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Thank you, Ms. Smith. Colleagues, we have several hearing requests on this item as well. Only one, in my view, has clearly met the requirements to be entitled to a contested case, and that's Steve Yon, who owns property on the discharge route less than a half mile downstream from the proposed outfall. He articulated relevant and material concerns both in timely comments and in a timely hearing request, and has demonstrated personal concerns that are different from the general public, so I would grant his request. There are 3 other requests that are a little bit more difficult for me. Laura Branson, David Flower, and Alan Homan have met the procedural and substantive requirements, except that while they're located in the general area of the proposed facility, it's a little unclear to me whether they are located close enough to be affected different from the general public. And so, colleagues, in a moment, let me just ask for your views on those 3. The remaining requesters are located either too far from the proposed outfall and discharge route to be affected different from the general public, or they've failed to raise personal concerns that are within the Commission's jurisdiction on this application. For example, as I suggested earlier, we lack legal authority to consider property values, noise and traffic, and those sorts of issues. So let me pause there and gather your thoughts, particularly what to do with Ms. Branson, Mr. Flower, and Mr. Homan. Commissioner Lindley?
I'm in agreement. This one was a little tricky, and so I think the best option, what we should do today is, like you suggested, grant the hearing for Mr. Yon and refer those 3 individuals to SOA for effectiveness.
Commissioner Janeka?
I reached the same conclusion. I think it was a little unclear to me precisely where on the map provided in the backup where the facility or outfall would be relative to those 3 requesters. I thought their concerns were otherwise in that marginal could be, and allowing SOA to make that determination is appropriate, in my opinion.
Okay. Well, I'm glad I'm not alone in my uncertainty, and I appreciate that. So that certainly sounds like a plan. We'll refer Mr. Yon, and then for a hearing, the other 3 for an effectiveness determination, and deny the remaining requests. And with that, let's take a look at the issues. And again, I sound like a broken record here, but we refer issues of fact that have been timely raised by an affected person and that are relevant and material to the application. And I think Mr. Yon appropriately identified 4 issues. First, whether the draft permit will be protective of surface water quality, whether the applicant has satisfied the notice requirements, whether the draft permit is appropriate in light of need, as that requirement is articulated under Texas Water Code Section 26.0282, and whether it will be adequately protective of endangered species and other wildlife. So that's how I would frame the referred issues. Commissioner Lindley, how does that sound?
Both those issues?
Commissioner Janeka?
I think those capture all of the relevant issues raised. Agree.
Okay. And then I think the same on this one. We would include an ADR referral and allow it 180 days. And if that sounds good to you, I'll entertain any additional thoughts or emotion.
I would move that we grant the hearing request filed by Steve Yon We refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA scheduling efforts. That we refer the hearing request of Laura Branson, David Flower, and Alan Homan to SOA for a hearing on effectiveness. That we deny the remaining hearing requests. That we refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit will be protective of surface water quality. B, whether the applicant has substantially complied with all applicable notice requirements. C, whether the Commission should deny or alter the terms and conditions of the draft permit based on the consideration of need under Texas Water Code, Chapter 26.0282, and D, whether the draft permit will adequately be protective of wildlife, including endangered species, and finally set the hearing duration for the proceeding at 180 days from the date of the preliminary hearing to the issuance of the proposal for decision.
I second that motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Ginecka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 4 is the consideration for approval to publish and solicit public comment on 2 total maximum daily loads for indicator bacteria in the Caney Creek watershed. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Kerry Neiman with the Water Quality Planning Division in the Office of Water. With me today are Jason Leifester with the Total Maximum Daily Load Program and Stephanie Scogan with the Environmental Law Division. Today, the Executive Director is requesting the release for public comment of 2 total maximum daily loads for indicator bacteria in the Caney Creek watershed. The TMDLs cover 2 assessment units in 2 stream segments within Brazoria, Matagorda, and Wharton counties. A stakeholder group was formed with balanced representation of all interested parties and was tasked with providing input on the TMDLs. The development of this document included an active public participation effort coordinated by TCEQ and the Houston-Galveston Area Council. The success of this project is due to the collaborative effort of the individuals and organizations that put in the time to develop this document to improve water quality in their communities. The Executive Director respectfully requests approval to publish the total maximum daily loads for public comment. Permission is also requested to make non-substantive and clerical corrections before providing the document for public notice. Thank you, and we are available for questions at this time.
Thank you, Mr. Neiman. I have none. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Ginecka?
None at this time, thanks.
Ms. Smith, has anyone signed in to speak on this item?
No one signed in.
And let's hear from OPIC.
OPIC recommends approval to publish and solicit public comment on 2 draft maximum daily loads for indicator bacteria in the Caney Creek watershed as presented by the Executive Director.
Thank you, Mr. McWhirter. I agree, colleagues. These draft TMDLs appear to meet all of the Clean Water Act requirements. I think it's appropriate to put them out for comment, and I'll entertain any thoughts or comments from you or a motion. Commissioner Lindley?
I have no thoughts or comments.
Commissioner Ginecka?
I will come in with the motion. I move that we approve the publication of and the solicitation of public comment on 2 draft total maximum daily loads for indicator bacteria in Caney Creek in the Brazos, Colorado coastal basin as recommended by the Executive Director.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote? Commissioner, would you repeat that? I didn't hear it on my end. I saw your lips move, but I couldn't hear you.
Aye.
Thank you. Commissioner Ginecka?
Thanks, Chairman. I heard the same thing from my end, so I vote aye.
Okay. And I also vote aye. So we're unanimous again. The motion carries. Ms. Smith, please call the next items.
Items 5 through 6 are the consideration for the approval to publish and solicit comment on 1 draft total maximum daily load and the corresponding implementation plan for indicator bacteria in Arenosa Creek in the Bays and Estuaries Basin. The Executive Director's staff is here to present these items.
Good morning again, Mr. Neiman.
Good morning. For the record, I am Kerry Neiman with Water Quality Planning Division in the Office of Water. With me today are Nicole Reed with the Total Maximum Daily Load Program and Stephanie Scogan with the Environmental Law Division. Today, the Executive Director is requesting the release for public comment of one total maximum daily load and one implementation plan for indicator bacteria in Arenosa Creek. The TMDL covers one assessment unit in one stream segment within Jackson, Lavaca, and Victoria counties. The stakeholder group was formed with balanced representation of all interested parties and was tasked with providing input on the TMDL and making decisions regarding the implementation of the TMDL. The development of these documents included an active public participation effort coordinated by TCQ and the Texas Water Resources Institute. The success of this project is due to the collaborative effort of the individuals and organizations that put in the time to develop these documents to improve water quality in their communities. The Executive Director respectfully requests approval to publish the total maximum daily load and implementation plan for public comment. Permission is also requested to make non-substantive and clerical corrections before providing the documents for public notice. Thank you, and we are available for questions at this time.
Thank you, Mr. Neiman. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
No questions. I did have a comment for Mr. Neiman. I just wanted to thank those remarks you provided about the stakeholder input, and I wanted to thank you and the rest of the staff that you worked with on this. I think it was I saw a good piece of evidence where you looked and listened to some of the stakeholder feedback on the source analysis component of this plan. So I was really pleased to see it, and just want to compliment the work.
Thank you very much, Commissioner.
Thank you for that, Commissioner Janeka. I think we don't thank our outstanding staff quite often enough, so I appreciate you doing that. Ms. Smith, is there anyone signed in to speak on these items?
No, there's no one signed in.
And Mr. McWhirter, what are your thoughts?
OPIC recommends approval to publish and solicit comments on one draft total maximum daily load for indicator bacteria in Arenosa Creek watershed and the corresponding draft implementation plan as presented by the Executive Director.
Thank you, Mr. McWhirter. I agree. Again, this draft TMDL, along with the implementation plan, appear to meet all of the Clean Water Act requirements, and I think it's appropriate to put them out for comment. Commissioner Lindley?
I'm in agreement, and I can make a motion.
Great.
That we approve the publication of and the solicitation of public comment on the draft total maximum daily load and the corresponding implementation plan for indicator bacteria and Arenosa, wasn't that right, Creek in the bays and estuaries basin as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
I vote aye.
I also vote aye. The motion carries. Ms. Smith, please call the next items.
That takes us to our enforcement docket, items 7 through 28. The Executive Director's staff is here to present these matters.
Good morning.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today is Brian Sinclair, also of the Enforcement Division, and Charmaine Backens of the Litigation Division representing the Executive Director. Pending before you are items 7 through 28. The total assessed administrative penalties are $658,717, with $104,587 deferred, $208,718 applied toward supplemental environmental projects, and $345,412 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. And let me pose one question, and that is on item number 24 concerning Equestrian Estates public water system. And my question is, where are we with respect to ensuring that the folks who live in Equestrian Estates have safe drinking water? It looks like in Mr. Fletcher we're dealing with maybe a recalcitrant actor or somebody who's not taking his regulatory responsibilities seriously. I don't know if that's an accurate or fair characterization, but that's how I'm reading it. And I'm wondering if you could offer any insight to where we are with Mr. Fletcher, and more importantly, where we are with respect to the quality of the drinking water for the residents of that neighborhood. And let me add that I realize I'm putting you on the spot. If you don't have an answer ready, we can loop back to you in a few minutes. And if it's going to take more time than that, I'm happy to take an answer offline. My colleagues may be interested in hearing that themselves offline. I'll leave that up to them. But let me be clear that I support the agreed order. I'm just curious about what we're doing with respect to this regulated entity moving forward. Ms. Cordell?
Chairman, this is Brian Sinclair. I believe we have Jake Marks that was going to be able to speak to this issue. I'm not sure if he's on or not.
Mr. Marks?
Good morning, Chairman, Commissioners. This is Jake Marks, representing the Executive Director and the staff attorney assigned to this case. I guess at the outset, the Office of Compliance and Enforcement is looking for this, order to be approved today so that it can start the tracking process and ensure that respondent complies with any outstanding ordering provisions. OCE is aware of the past history of noncompliance with this respondent and is going to track this case accordingly. In regards to the violations themselves, a respondent returned to compliance within the Drinking Water Watch database for the corrosion control study, having satisfied small system cessation, and that involves conducting 2 consecutive 6-month monitoring periods where the system does not exceed lead action levels. In terms of the lead tap samplings, the system did not do the 2016 testing, but later conducted that testing in 2017, again returning the system to compliance within the Drinking Water Watch database. There are still some outstanding public notification requirements that Executive Director is seeking compliance with, as well as that the system implement improvements with the facility's processes to ensure similar violations like these don't occur in the future. I'm available for any questions you have as well.
Thank you, Mr. Marks. I appreciate that, and that helps fill in my view a little bit. It sounds like there have been some efforts with some improvements. We're not entirely there yet. I'm reluctant to get into specifics about any potential violations that could come before us in the future, and so I'll try to avoid that, but leave it to the good judgment of OCE how to support Mr. Fletcher and bring him along into full compliance. Whether that's with additional counseling coming from our, it's really we have a spectrum. Our small business local government assistance program all the way up to the Attorney General's office, and I'll defer to OCE on whether they need the Attorney General's office to educate Mr. Fletcher, or if just some outreach from agency staff will be sufficient to do that. But Mr. Marks, I appreciate the presentation. I think that's answered my questions. I don't have anything further for the Executive Director on any of the docket at this point. Commissioner Lindley? You're on mute.
All right, thank you. That was helpful. Appreciate you asking the question, Chairman, and thanks, Mr. Marks, for that response. I'm comfortable moving forward adopting the items in front of us today.
Commissioner Ginecka?
I appreciate very much your question, line of questioning, Chairman. I think I had the same concerns in terms of looking at some of the outstanding obligations this respondent, particular respondent for this matter, still owe to our agency. I am a little concerned just in terms of looking at the resources necessary to address this violation, knowing how resource intensive and costly it is to run these sorts of water systems, and seeing that amount of past due penalties. But I trust OCE's and our executive director's judgment, where if movement isn't being made, or it doesn't look like there's high prospects of realizing those owed obligations, that we'll be able to take the appropriate actions at that time. So I'm in agreement with the two of y'all as well. Good to move forward today.
Thank you. Ms. Smith, is anyone signed in to speak on the enforcement docket?
We have somebody signed in on 13 who indicated that they don't wish to speak, and their presence will be noted for the record, but we don't have anyone signed in to speak.
Thank you for that. Mr. McWhorter, what are your thoughts?
My office has reviewed all of these items, and we recommend approval of all of the proposed orders. I did just want to note with respect to item 12, as everyone, all of you know, I'm sure there is some history of compliance history with this particular respondent, and I know those violations are unrelated to these air violations, but just with that background, my office does tend to get a lot of contact from the public with respect to this facility, and we're comfortable with the order. We think it's appropriate. With respect to the technical requirements, we're hopeful and we're sure there will be vigilance in ensuring that with these violations, the company comes into compliance and the appropriate certification requirements are satisfied in a timely manner. So with that, that's all I have, and we do recommend approval of all of these orders.
Thank you, Mr. McWhorter. Yeah, unfortunately, that regulated entity is a name that's familiar to us for the wrong reasons. This is certainly a very significant penalty that reflects some very serious violations. I do think that this order is appropriate, so I'm also prepared to move forward on it. But I appreciate you flagging that one. It certainly did stand out to me as well. Colleagues, at this point, I think I'm ready for any additional thoughts or a motion. Commissioner Lindley?
I don't have any other thoughts. Thank you.
Commissioner Janeka?
I do want to steal the spotlight for 2 seconds and just say I appreciate Mr. McWhorter, your comment on that. I think that was an item that I've looked through closely as well. I had quite a few things I was concerned about, but I agree with the chairman's assessment of it. And I'll just move that we adopt. I'll make the motion that we adopt items 7 through 28 as recommended today by the executive director.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 29 is consideration of the monthly enforcement report. The executive director's staff is here to present this matter.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me is Brian Sinclair of the Enforcement Division, as well as Charmaine Backens of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2021 through November. There were 268 effective administrative orders issued, and of those, 38 contain supplemental environmental projects. These orders assessed a total of $2,821,272 in penalties, with a payable amount of $1,824,508. $509,496 are to be paid for supplemental environmental projects. 3,611 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 343 enforcement action referrals have been received. There are 1,483 pending administrative orders, with 194 cases that are on the backlog. 210 cases are pending at the Attorney General's Office for representation in District Court, and 3 judgments have been issued. 2,073 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2019, 20, and 21. We are available to answer any questions you may have.
Thank you, Ms. Cordell. The only question I have relates to the backlogged orders. We're running higher than we normally do there. I wonder if you could speak, perhaps to the driver or the cause of that, but more importantly to what we can do to bring that number down.
Yes, Chairman, this is Brian Sinclair. We continue to, the Enforcement Division and the Litigation Division both are working to try to bring the backlog down, meeting with staff to ensure that anything that's backlogged or approaching backlog continues to move, and that we make every effort to get it knocked down. We've not been successful with that effort yet. But we continue to redouble our efforts there to get the ones that are on backlog off and to prevent additional cases from going on to backlog. There's not just one reason. The reasons are varied, and so I can't really say that it's one thing in particular, but it just requires a constant vigilance, and with the volume of cases that we handle, you just have to make sure that things continue moving and nothing kind of falls in the cracks or doesn't get acted on in a timely way. So again, we've redoubled our efforts. We're meeting with staff on a biweekly basis to make sure that any issues that are preventing movement of cases are addressed, and we make decisions quicker on these things so that they don't stop.
Thank you, Mr. Sinclair. I appreciate that. Looking at the information, it certainly looks like the line has flattened out over the last month. So we're, decelerating on generating more backlog orders. Hopefully that's the beginning of a turning of the tide on this. But we'll just continue to monitor it, and I appreciate the efforts of your office to bring those numbers down. Commissioner Lindley, anything for the executive director staff?
No, thank you. I'm good.
Commissioner Ginecka.
I appreciate the question you asked about the backlog orders trend, Chairman, and just want to second your sentiments. And I'll add, I appreciate, Mr. Sinclair, how much staff always have to juggle extraordinary tasks. And right now it's the season where the legislature is in session, and that creates a lot more interest and perhaps more urgent questions coming down to your office and all parts of our agency. So I especially appreciate that continued work to help address that backlog, and please do continue to let us know if there's ever a point we need to try and marshal resources from different points in the agency. Much appreciated.
Thank you, colleagues. Ms. Smith, has anyone signed in to speak on this item?
No one is signed in.
Thank you. Mr. McWhorter, what are your thoughts?
I didn't have any questions. I appreciate the report. Thank you.
Thank you. And colleagues, there's no action necessary on this item. So, Ms. Smith, Mr. Sinclair, Ms. Cordell, thank you for your presentation. And Ms. Smith, I'll ask you to call the next items.
The following items, 30 through 33, are for executive session, and the Commission will meet in closed session via video conference or teleconference. How many minutes would you like?
Colleagues, how does 10:20 strike you? Does that work? Great.
So they'll meet in closed session at 10:20 as permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 551.074, and the Governor's March 2020 Executive Order regarding the Open Meetings Act, to take up and consider matters pursuant to items number 30 through 33 as posted and noticed.
Thank you, Ms. Smith. And colleagues, what we're going to do is in a moment after we recess and drop off this meeting, join the executive session meeting. If I can find the link for that, that's why I was begging for more time than usual. In the unlikely event that we take any action in executive session, we'll return here to announce that. Otherwise, I'm going to ask our general counsel to return to gavel us out. And with that, the time is 10:14 a.m. and we stand in recess.
Mary, can you hear me?
I can. Thank you.
Thank you.
The Commission met via video conference for closed session from 10:20 a.m. until 11:03 a.m. on item number 30 as posted in notice pursuant to Texas Government Code, Section 551.074. No action was taken. This agenda stands adjourned. The time is 11:05.